Welcome to this personal tax roundup for this month, and my name is Dean Wootten. Initially we're going to look at a benefits in kind situation, and it concerned Timothy Norton and his company, Tim Norton Motor Services Limited. Now, the company ran a Ford car dealership, and they sold new and used cars and undertook repair work, etc. So typical motor dealer. Now the company owned a Maserati and a Ford GT40. These were obviously very sporty cars, very important cars for the business. I got a lot of publicity from those cars. So those cars were retained and took to sales shows, etc. But they're very, very nice sporty cars. Now, when the director, Tim Norton, wanted to use either car, he would sort out the road tax before it was used, and he would issue or complete a statutory off-road notification after he's used it. So effectively, every time he's using it, it's deemed to be on the road, and when he's not using it, off the road. Now, HMRC concluded that these cars had been made available to Tim Norton more than the P11Ds indicated. They then issued NIC determinations for 2010 through to 17, and income tax assessments from 1213 to 1415 and 1617, and issued a closure notice for 1516. This was all in respect of missing benefits in kind, or understated benefits in kind. Now, the first tier tribunal found that it was easy to remove the SORN status, and the cars were available to Tim Norton even when no road tax had been paid. Now, this case went all the way through to the upper tribunal. Now, as a director of the company with sole access to the car keys, Tim Norton could easily revoke the SORN, could easily pay the road tax, and could easily gain legal access to drive the cars. Yeah, being available for private use is quite difficult to establish. I mean, it's easier for companies than it is for a sole trader, but this was a company case. And even with this company case, it was in the upper tribunal unlikely that the car wasn't available for private use. He just used it whenever he wanted. So therefore, it was available for his use. Now, saving grace, well, not saving grace, but a little bit of a sweetener, the tribunal agreed that the 1617 discovery assessment was invalid. It had been made during the inquiry period, so it couldn't satisfy section 29(5). You had to wait until the window had shut before you issued this discovery assessment, because all the time the inquiry window is open, then that's the route you should take, i.e. open an inquiry. Let's now look at a domicile case, and this concerned Jeremy Collar. Now, Mr. Collar submitted his tax returns on the basis that he was non-UK domiciled and eligible for the remittance basis. Now, following an inquiry, HMRC issued closure notices for the tax years ended 5th of April 13 through to 16, and they argued that he was domiciled in England, and therefore he was taxable on an arising basis, not a remittance basis. Now, just to give you some background on this, his father came to England during World War II. He was Austrian by birth, and he spent the rest of his life here. His mother was born in Ireland, but lived in England from 1953. Now, Jeremy was born in England and lived here all his life. The issue was where he was domiciled from April 12. Now, first it stated that if HMRC succeeded with any one of the following issues, the appeal would be dismissed. Now, issue 1. When Jeremy was born on the 17th of May 1958, had his father acquired an English domicile of choice, making Jeremy's domicile of origin England? Issue 2. When his father died in August 1968, had he acquired an English domicile of choice, meaning that Jeremy had an English domicile of dependency, which became an English domicile of choice when he ceased to be a minor on the 17th of May 1974. Issue 3. If his father had not obtained an English domicile of choice by his death, had his mother acquired an English domicile of choice after his death, so that Jeremy had an English domicile of dependency, which became an English domicile of choice when he ceased to be a minor on the 17th of May 1974. Issue 4. if Jeremy had an Austrian domicile of origin that remained unchanged until he turned 16, had he later acquired an English domicile of choice before his claims for remittance basis in April 2012. And remember, any one of those would, unfortunately, mean that Jeremy would lose this case. Now let's look at issues 1 and 2. Now, by the time Jeremy was born, his father had acquired a domicile of choice in England, and this continued to his death. His father severed all ties with Austria, and he lived in England with his wife and children. He holidayed in France, but there's no evidence of his intention to move overseas. So based on this, his father's origin status, Jeremy's domicile of origin was England. Let's consider issue 3. It wasn't really necessary because obviously you only had to hit one of the issues, and issues 1 and 2 were hit, so therefore the case was lost. But they went on to consider issues 3 and 4. Now, by the time that Jeremy was 16, his mother's domicile of choice was England, where she raised her children, married again in her 50s, and later died. Had the tribunal not concluded that Jeremy had an English domicile of origin, he would have acquired an English domicile of dependency from his mother. So another loss. And again, not necessary, but they went on to consider issue 4. Now, Jeremy Collar owned property in the UK where he'd lived all his life. He'd married in England and raised his family here. Having applied for Israeli citizenship, he claimed that he was domiciled in Israel. But this was only planned after his divorce in 2012. He owned property in England and nowhere else. Properties outside the UK were only bought from 13. If prior to 2012, he had acquired domicile of origin outside the UK, by 2012 he would have acquired a domicile of choice in the UK. So unfortunately, Mr. Collar was held to be UK domiciled and therefore taxed on an arising basis. He didn't get the remittance basis. It's quite a good case to look at for domicile because it goes through the issues that would have scuppered his situation. We'll now move on to EIS certificates. Now this concerned Dr. Syed Rizvi. Dr. Rizvi subscribed for shares in 5 companies and claimed EIS relief from 1415 through to 1617. It later transpired that he didn't hold the required EIS3 compliance certificates, which obviously you need for valid EIS claims. He didn't dispute that he was not entitled to make the claims. He didn't have the certificate, so he couldn't really dispute it. Now, on the 12th of March 21, HMRC raised discovery assessments, but Dr. Rizvi argued these were out of time, making them invalid. HMRC argued that the assessments were in time on the basis that Dr. Rizvi, or someone acting on his behalf, had been careless. Now, first he decided that Dr. Rizvi, he wasn't careless. It was reasonable to rely on his accountants. But his tax advisor, acting on his behalf, had acted carelessly by not checking that the correct certificates had been obtained when claiming EIS relief. And this, apparently, according to the first tier, was carelessness of a high order. So unfortunately, the appeal was dismissed and discovery assessments of almost $255,000 were upheld. So it just goes to show we've got to be, as advisors, very, very careful on any claim really, but EIS, this particular case was about carelessness of a high order because the accountants, the advisors claimed EIS without looking at the relevant paperwork, see if it was valid or not. A quick look at a film rights scheme. This concerned Thomas Good. Now, Thomas Good entered into a film distribution rights avoidance scheme. And as normal with these schemes, trade was set up into transactions to buy, enhance, exploit and sell distribution rights worldwide. He bought the rights using $300,000 of his own money and a loan from the scheme operators. Under the scheme, investors were entitled to a minimum annual payment to cover the loan interest payable on the loan, and they assigned their rights to the minimum annual payment income to the lender. Now, the scheme promoter claimed that the minimum annual payment income and interest payable would be netted off for tax purposes. So essentially, the interest payable was tax deductible because you'd expect the income to be taxable. So therefore, the interest payable to make the scheme work should be tax deductible. Now, early years trading losses would be incurred, which would be available for sideways relief, which obviously these schemes are chasing. So what happened next? Well, HMRC argued that the losses were not trading losses, and they issued discovery assessments disallowing the deductions for the loan interest payments. So they wanted income tax on the interest received, the minimum payments received. Now, by the time the Court of Appeal hearing, it was accepted that the scheme didn't work. The losses generated were not trading losses, they weren't available for sideways relief, and the interest payments were not tax deductible. But Mr. Good argued that he had assigned the MAPS payments to the scheme provider, as the right to receive that income was not his. He derived no benefit from the payments. The sum was not taxable on him. So it's just another way of trying to counter the failing of this scheme. He wasn't going to get tax deductions on the interest, so therefore why not argue that the interest received wasn't his and wasn't taxable? Now this went up to the Court of Appeal, and the question was, did the MAPS represent income from non-trading business of exploiting films? So that was the issue. If so, liability tax will arise on any person receiving or entitled to the film income. And the Court of Appeal found that the person who received and the person entitled to the income could very easily be two different parties. Now, unfortunately, for Thomas Good, he was entitled to the MAP payments. He benefited by assigning the payments to settle the loan interest that was due, and redeemed his rights to the MAP's related income once the loan was paid off. So based on the economic and commercial reality, the appeal was dismissed. Let's now look at a case concerning the additional 3% supplement for SDLT. So when you have more than one property, residential property, then obviously you pay the 3% supplement. There is a relief for that if you are replacing your main residence. So if I own a buy-to-let and a main property, if I was selling my main property where I live, and then the lawyer would say, right, how many properties have you got? And you say, well, I've got 2. So therefore, it looks as though you're going to pay the 3% supplement, but you are replacing your main residence. So therefore, you don't pay the 3% supplement on the replacement of a main residence, even though you own more than one property. Now, in this particular case, Benjamin Cohen lived with his parents in Essex, and he invested in several properties with his father. Now, in July 18, he bought a London property in need of renovation. He moved into that property in August 18, once the work was completed, and lived there for 10 days. Now, on the 25th of October 18, he sold that property to his parents, and he completed the purchase of a new flat on the 30th of October 18. Now, his SDLT return did not include a charge for the extra 3% supplement. He argued that it was a replacement for his only or main residence, which he only occupied for 10 days. He obviously had other properties, so therefore the one he was, the flat that he was moving into, he was arguing it's a replacement of a main residence. But that main residence that he's replacing, he had only lived there for 10 days. Because remember, he lives with his parents. Now, HMRC opened an inquiry and later concluded that the higher SDLT rate was due. Now, the first tier decided that Mr. Cohen had decided to buy the new flat before moving into the first property, i.e. the flat that he was going to live in, properly live in. He decided to do that before he moved into the other property for 10 days. Now, correspondence confirmed that he paid a holding deposit on the flat he was moving into, properly moving into, in mid-August. He didn't want to live in the first property, in the 10-day property. The first property was never his only or main residence. Living temporarily there for just 10 days is not going to make it a main residence. There's not that permanence there. So the flat that he was going to move into properly was not a replacement of his only or main residence. He didn't have an only or main residence. So therefore he can't get that relief for replacement of main residence. Now, the high rate of SDLT was unfortunately due on that flat purchase, and the appeal was dismissed. So when you start looking at this case, it looks like it might be a PPR case, moving in there for 10 days, which is always dodgy anyway. But this was an SDLT case, but very similar principles to establish whether it was a main residence or not. Let's now look at a case of negligence, and it's obviously relevant for accountants. Obviously, we don't want to be in this position, but occasionally there might be something that we come across that we might be a little bit exposed on. Now, in 2009, following advice given by Speechley Bircham LLP, RBC Trust Company established a non-resident trust on behalf of Stephen Ettroy, a UK resident non-domiciled individual. Now, I don't think what they did was relevant for this particular case. What they did didn't work. So it's what happens when things don't work, and we've possibly advised on that. Now, in September 18, following an investigation by PwC, the advice that had been given was found to be wrong, and that led to additional IHT liabilities in excess of £1 million. Now, Mr. Ettroy instructed lawyers, and in May 2021, a claim was made against the LLP that gave the advice. Now, both parties agreed the advice had been wrong, but as the advice was provided over 6 years ago, before the claim was made, then Speechley Bircham LLP argued that the claim was time-barred. This went up to the High Court. Now, ordinarily, the 6-year time limit applied, but for a negligence claim, this was extended by 3 years. So the additional period starts when the claimant obtains both the knowledge of the material facts relating to the damage and that the damage was attributed to that negligence. Now, required knowledge only arose in September 18 when PwC reported their findings, and it was only then that Mr. Ettroy knew that a claim was serious enough to pursue. Now, that meant the 3-year period started in September 18, and the claim raised in May 21 was in time. It had to be raised by September 21, effectively, to be in time, and it was. Well, let's just finish off this roundup by looking at a few important bits and pieces. I've started looking at payroll benefits from 6th of April 2023. That's when you want to just put your car benefit through the payslips effectively. And now, useful if you want to do that, but you've got to register for payrolling benefits. Now, HMRC have stated they would no longer accept informal payrolling benefits arrangement. If you want to payroll benefits, you must register for payrolling benefits before the start of the tax year. So if you want to payroll cars or private health, then you do that before the start of the year. And what the system will then do, will take the car benefit or the payroll benefit, it will divide it by 12, and that amount will go through each month as though it were gross pay on your payslip. Obviously, you won't be paid it, but it's just on there to work out the tax that will be deducted on that particular payslip. So very useful. The official rate of interest is going up to 2.25% from the 6th of April 2023. Not unexpected, obviously, with interest rates going up. Now, the extension to the NIC top-up window, as championed by Martin Lewis on his programmes, now, allowing individuals to fill any gaps in their NI record between 06 and 16 to obviously maximise their state pension. And this deadline was going to be the 5th of April 2023. But unfortunately, trying to get on the pensions website is problematic. It's just busy all the time, and you just can't get on it. And because of that, the deadline has been extended to the 31st of July 23. Wouldn't surprise me if it was extended longer. And because if you still can't get on the website, then extending it from April 23 to July 23 is not going to make a lot of difference. But it is something that if you have got gaps in your NI contribution record, then you can buy extra years. So you go on the website, find out if you've got your gaps, and then you've got the option of buying those extra years to secure a maximum or full state pension. And finally, reporting residential property disposals. Now, where possible, you should use the online service. I'm sure accountants would be using the online service, but taxpayers may not if they haven't got advisors. Now, those who can't submit their return online, they may use a paper return, and this form is now available to download on a trial basis. But I think as accountants, we'll be using the online form. Well, that concludes the roundup of various personal tax issues for this month. My name's Dean Wootten. Thank you for listening.